Today was day 8 in Donna Adelson's trial, and there were so many very important developments that happened today from the beginning of the day till the end of the day. So if there's any video that you're not going to want to stop in the middle, this is it, because even at the end of the day today, there were some very important developments that we're going to show you what happened. A lot of people missed this, but we didn't. We were right on it, and we saw, even though there was some attorneys talking and there was some argument with the judge and not everyone knew exactly what was going on, we figured it all out, and we're going to play for you why this is so significant and why it's so critical of a development in this case. So before we get to the recap, I do want to remind everybody that tomorrow is closing arguments in this case. So the defense rested, and tomorrow each side is given 2 hours for closing arguments. We'll see if they use all of the 2 hours, but that's going to happen tomorrow, 9 a.m. So join us right back here, Brother Counsel Studios, for the live stream of Donna Adelson's final day of the closing arguments, and maybe we'll even have a verdict tomorrow. Okay, let's jump into the recap of what happened. So the first witness that was called was Kristen Adamson. Now, what's important about Kristen Adamson is that even though she is an attorney, she's a lawyer, she was called as Wendy's family law attorney. She represented her in the divorce with Dan Markel. She was not called as an expert witness. Now, that's very important distinction, whether someone's being called as a lay witness or as an expert witness. Okay, so the first witness, Kristen Adamson, was called as a regular witness, a lay witness, just to talk about what happened in the divorce case. Now, also, after Kristen Adamson testified, there was Linda Bailey. Now, Linda Bailey was called as an expert witness. And there's a very important distinction that we're going to see shortly how this all played out. But let's first talk about what Kristen Adamson testified about. So essentially, she was there just to go walk through some of the proceedings, what was going on in the divorce case, and just to try to convince the jury, essentially, that this was not really a contentious divorce. And the issues that were brought up were common issues, and she was expecting certain rulings. It wasn't such novel and nasty issues that she's seen personally as a lawyer as going through this case. So she was just explaining what was going on and talking about the relocation issue and talking about the grandma motion and things like that. So that was really what she was doing. And also she happened to say that there's nothing wrong with offering a bribe, as we keep hearing about in this case, the bribe that the Adelsons offered Dan Markel to move down to Miami, to relocate to Miami. There was nothing wrong with that. People do that all the time, and they try to convince the other person either to relocate or to not relocate. Either way, and it's completely fine. There's nothing wrong with that. So essentially that she's walking through some of the attorney fees issues, just really rehashing a lot of the divorce file, which is not so relevant to the case. The whole question about this is whether this was a contentious divorce, and she was really there just to basically said that this was not contentious. Okay. Now, then after her was Linda Bailey. Now, before Linda Bailey took the stand, there was an issue. What was the issue? Well, the issue was that Linda Bailey actually sat in the courtroom when Kristen Adamson testified. Now, normally we have an issue with that because we have a sequestration order, which requires that all witnesses that are going to be testifying cannot watch other parts of the trial, right? Everybody knows that. So what was she doing in the courtroom watching this testimony of Kristen Adamson? So actually, this was an issue that was discussed at sidebar. We did not hear this issue. Even if you were following along with the case on the live stream, you did not hear this discussed because this was discussed at sidebar. And what the prosecution said is that at sidebar, they never agreed that Linda Bailey should be able to sit in the courtroom and watch and listen to Kristen Adamson testify. So the prosecution was upset about this because this was not the first time that a sequestration order was not followed. It was violated. Just like we saw yesterday, the realtor, I believe, he also was sitting in the courtroom, even though really had nothing to do with his testimony, but that was a violation of the sequestration order. And you, as the attorney, have the responsibility to make sure that your witnesses understand that they cannot be in the courtroom. So this was the second offense, right? And therefore, the prosecution asked the judge to preclude Linda Bailey from testifying at all because she violated the sequestration order. And the defense said, no, this was not the agreement. The agreement was that she was able to listen to the testimony. So listen to what happened. What happened here is that the judge actually asked the court reporter to pull up the sidebar where they discussed this and to see what the agreement was, what the discussion was all about. So this is where they pulled it up, and now we're going to listen in on to what happened here when they have the transcript now of what happened at sidebar.
I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts in reference to lay witnesses.
And I apologize again about the audio. There's nothing I can do about it. For some reason, the audio in the courtroom is just not that great. And I actually turned down my mic, so it shouldn't be so blasting and the court not be blasting. But I apologize. I'm doing the best that I can.
Experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
So Georgia Kaufman basically said that we agreed that experts like Linda Bailey cannot listen to lay witnesses' testimony. Now remember, Kristen Adamson testified as a lay witness, not as an expert witness. And that's a very important distinction because Georgia said that the agreement was that other experts maybe can listen to other experts' testimony, but not lay witnesses' testimony. And let's see what the response here is.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what's being discussed now.
So the judge is saying, sorry, the state never agreed to that. State never agreed that your expert should be able to listen to the lay witness's testimony. That's what it says in the transcript.
Why should this witness be permitted to testify?
Now the judge is saying, well, then tell me why I should let this witness testify. There's a clear violation of the sequestration order, and if you're going to cite to this sidebar, the prosecution never agreed.
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes. But the state made no agreement as to anything about an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
So really, he's got him dead to rights. I mean, there was no agreement, and this is why it's very important as a lawyer to make sure you know what you're agreeing to, what you're not agreeing to. And here, they just dropped the ball. Again, they're trying to argue, well, yeah, we did bring it up. You're right, you brought it up, but the prosecution did not agree to that. The prosecution agreed that maybe Linda Bailey can listen to other expert witnesses, but not lay witnesses. So then they basically there's a little bit more argument, and then the judge finally comes back. Judge Everett comes back with his ruling. Now the question was, okay, what should we do about it? And here, Georgia Kaufman said, well, exclusion. We cannot allow this witness to testify if they violated the sequestration order. And it's not the first time, it's the second time that the defense did this. And it has to be a fair trial, both for the defense as well as, as well as the state. So it's just not fair to the state. So now let's just go ahead to the ruling here. Here we go.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412-72nd-332.
So just understand, there was a proffer that was given, and basically was, well, the issue is, did the witness who listened to some other testimony, did they change or alter or modify their own testimony based on what they heard by violating the sequestration order? And there was a proffer outside of the presence of the jury in which Linda Bailey got up and said, no, nothing changed about her opinions about watching Kristen Adamson. It was all based on her review of everything that she was allowed to review. So that's what she testified to. And now the judge is going to base his opinion based on what she said. And remember, the exclusion is always the most severe sanction. And when you have a criminal defendant and they have a Sixth Amendment right, you're always going to usually going to allow the person to testify. And that's what happens here.
The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains appropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter.
Okay, so what he said there basically was a very important point. And that is that even though he's not going to preclude Linda Bailey from testifying, but he will give a jury instruction, meaning that he's going to tell the jury, the prosecution has to write this jury instruction, but essentially he's going to give the jury an instruction about this violation of the sequestration order. So very similar to what we had, let's say in the Karen Reed case with the back of the hoodie of the sweatshirt, you're going to have a similar type of jury instruction that this person was in violation of the sequestration order. So there's going to be some sort of jury instruction which he is allowing as a remedy for this sequestration violation. Okay, so then we went on to Linda Bailey. Then she actually took the stand in front of the jury, and then she testified, essentially, again, going through all the divorce file at length, going through all the filings and explaining why this, in her opinion, was not a contentious divorce. And in fact, something that she brought up also was that the fact that Dan actually drafted a lot of the pleadings. They weren't drafted by the family lawyers that he retained. And that was something that she can tell on her own because she knows these attorneys and this is not how they write. And the way that it was written by Dan, whatever. So she's just going through a lot of the file, and basically just, again, saying that it's not contentious. And then that led up to this moment. Because there's obviously a very big difference between lawyers. Lawyers understand litigation. Like, we're in litigation all the time, right? A lot of litigation attorneys are in litigation all the time. So we're used to the banter. We're used to these filings. And someone can put something in the filings that to a regular person, if it's their case, they're reading it, they're like, wow, this is crazy. How can they say such a thing? And since we do this all the time, it's like, yeah, don't worry about it. There's nothing to worry about because we see this all the time and we've been through this all the time. And therefore, we're not going to be so moved by some allegations that are thrown into some pleading. So lawyers obviously are affected differently by what's put in pleadings than the client, because this is their first interaction with the court system most of the time, maybe their second, and they don't really know how this all works. So they could be thinking something is much more serious and it can make them much more emotional than it will an attorney who's used to this. So this is essentially what Georgia's point was on cross-examination. So this is where she got really worked up about it. But let's take a look at it and see how she goes about this. Here we go.
Highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you
Well, that's
agree
one
with
reason-
that?
No.
Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
And of course, that's the point, and that's true, right? So even as a lawyer, this is not a contentious divorce. Yeah, but the people going through it can be very emotionally affected by it. It can be the most important thing in the world to them. And yeah, maybe it will move down and it'll make her do crazy things and say crazy things. So that's not out of the ballpark. Just because you are such an experienced family law attorney, you've seen these cases all the time, and to you would rate this on the not so contentious. But who's to say what Donna would rate this as? How do you know what she's going through at the time? Don't you have to speak to Donna? So that was a very good point that you brought out on cross-examination. Okay, so then we moved on to Marissa Descalzo. Now, Marissa Descalzo was Donna Adelson's first attorney on this case. In fact, we covered one of the first hearings on this case was with Marissa Descalzo. And she's a criminal defense attorney, and she was called to the stand. Now, the first thing that happened before she was called to the stand is that this is an attorney-client relationship, right? Marissa did represent Donna Adelson. And just because you're not the attorney of record at this point, just because she's not trying the case, it doesn't mean that attorney-client privilege ceased to exist. Once it existed, it always exists for whatever you spoke about. So that attorney-client privilege remains. So the question is, how can Marissa Descalzo take the stand and talk about privileged information, privileged discussions that she had with Donna Adelson? So the only way that happens is that there is a voir dire. So the judge asks Donna Adelson, do you understand what's going on now? Your defense wants to call, you basically want to call your former attorney, Marissa Descalzo, to the stand to talk about some of the statements that you spoke to her about. And do you understand what's going on here? Do you understand that you're waiving the attorney-client privilege? Now, the way that this works is that the attorney-client privilege is held by the client. It's not held by the attorney. As an attorney, you're not allowed to divulge any attorney-client information because it's the client's. You're not allowed to talk about it. But if the client tells you, yes, I want you to share this information, well, then you have to share it. You can't say, well, I also have an attorney-client privilege that I don't want to share this information that we spoke about. It's not your privilege to hold. Okay, so Donna was the one who held the privilege, and that's why Judge Everett asked her before Marissa Descalzo took the stand, do you understand what's going on, and that she's going to be talking about those information? And she said yes, and for the limited discussions or limited topics that they spoke about, that's what she's waiving, nothing else. And that's when Marissa Descalzo took the stand, and she spoke about the statements that that Donna Adelson made to her about statements of going to sleep for a long extended period of time if Charlie is convicted, and that she spoke to Dan Rashbaum, and she spoke to, again, this is Marissa. Marissa spoke to Dan and spoke to the Florida bar about what they should do about when you have a client that makes those type of statements to you. What should you do about that? So they were in contact with the Florida State Bar about that. And they also discussed Vietnam. They discussed her taking a vacation to Vietnam. It was just a vacation. It wasn't fleeing or anything like that. And of course, there was no warrant issues at the time. And she would be allowed to travel if there's no warrant. But of course, if she doesn't mean that she's actually going to be able to board the plane and leave. That is still also a possibility. Okay. So then we heard from Sarah Newhouse. Sarah Newhouse is the victim advocate for the Tallahassee Police Department, and she was actually there when Wendy Adelson was being interviewed by the police. So she was a victim advocate for Wendy Adelson, and Wendy Adelson, after that police interview, called Donna Adelson to break the news to her that Dan Markell was murdered and killed. So the defense called Sarah Newhouse to see what was Donna's reaction. Did she have any sort of reaction? And she said yes, that Donna Adelson's reaction was that she sounded very shocked. She sounded very upset. Remember, like Wendy said, well, they sounded surprised, so that's a good thing. And this is Sarah Newhouse saying yes, Donna Adelson did sound shocked, did sound upset when Wendy Adelson called her after the police interview, breaking the news to her that Dan Markell was murdered. Okay, fine. Then we got to some very interesting points of this trial. So the one point is that we had to figure out whether Donna Adelson was going to testify or not. And here is where there was some back and forth, because the attorneys wanted to have a whole nother few hours to talk with Donna Adelson about whether she's going to be willing to take the stand or not. And what Judge Everett was not going to do was going to allow the day to break without getting a decision out of Donna Adelson. Because remember, yesterday on day 7, we broke early specifically so that they can discuss whether Donna Adelson should take the stand. So he's saying, I gave you all this extra time. Also, on top of that, you had all this time pre-trial to discuss whether she should take the stand. And yes, we understand that when new evidence comes in, you don't know exactly how it's going to come in into evidence, what type of evidence is going to come in, and therefore you may need to change your decision. But still, after all the evidence came in, they gave them the whole afternoon yesterday as well as today over the lunch break again, an extended lunch break to discuss with Donna Adelson whether she wants to take the stand. And then he gave them another 5 minutes because she still wasn't sure whether she wants to take the stand or not. So after this back and forth, giving her plenty of time, he said, okay, it's enough is enough. She's going to have to make the decision now. And that's when he went through the colloquy with her, and she said she is not going to take the stand. So Donna Adelson is not testifying, which is probably the better choice in this case. So she's not taking the stand, and now the defense basically rested. And I say basically because we're going to get to something in a moment. But first, something that I want to point out, and that was regarding Patricia Byrd. Now, why is this important? Well, because we heard something yesterday about Patricia Byrd. And I want to show you what we heard yesterday, some back and forth about Patricia Byrd, and then we'll come back to what happened today. So give me a moment. Let me just pull it up here. This was the testimony of one of the private investigators. Let me see if I get his name here. His name was, I think it was Eric. Let's see if I can get it here quickly. Eddie Varnes. So this is Eddie Varnes. And Eddie Varnes from yesterday spoke to Patricia Byrd on behalf of the defense. So he spoke to Patricia Byrd on behalf of the defense. Remember, Patricia Byrd was one of the jailhouse snitches. And she was the one that said that Donna Adelson admitted to her everything and said that she actually did this crime. She did the crime that she's accused of, and that she promised her a trailer and land and veneers. You all remember Patricia Byrd. And she also said that Donna Adelson tried to get her to say that when she was locked up with Katie McBanoa, Katie really admitted to her that this was all an extortion by Katie's boyfriend, Sigfredo Garcia, and that she was part of it. And so Donna Adelson wanted Patricia Byrd to testify that that's what Katie told Patricia. Okay, so this is what Patricia was talking to this private investigator about that story. So now listen to what happens here.
What she told me.
Okay, can you tell me again exactly what she told you?
I'm going to refer back to my report a little bit. That's okay. I spoke Patricia, and she said that they were sitting at a table talking about the case, and then Byrd quoted the following that McBanoa had told her, and that was, after we had him killed, we tried to get the money because we knew her boyfriend and family had a lot of money. We knew that they had money because the family offered the man $1 million apiece to move to South Florida. So at that time, Patricia and Katie, said, why not kill him and get the money ourselves? So then Byrd replied with, girl, that's crazy as hell. That's extortion. And Katie replied to her and said, my kid's got to be raised and go to college as well.
So I have a question about.
So you hear that? That is when he met with Patricia Byrd. And when he met with Patricia Byrd just told him about Katie McBanoa, about this conversation that Katie McBanoa had with her. Nothing about Donna Adelson admitting to her that she did it, or that promising her trailer or land or anything like that. This is the defense's private investigator saying that this is what Patricia Byrd, when he met with her, that's all the information that she shared with him. And then all of a sudden that changed for some reason, according to the defense, is changed because she wants, better treatment on her charges. She's facing 20 years in prison, and now she's changing her story so that she can make the prosecutor happy. Right. So, but according to this private investigator, this was the story, and that's it. What Patricia Byrd told him that Katie McBanoa told her. Now, if you hear this and you're the defense and this is your private investigator and this is what you hear from Patricia Byrd, and this is before she's deciding to cooperate with the prosecution, who do you think you should list on your witness list? You would think that Patricia Byrd should be the one that you list absolutely on your witness list. But listen to this.
So according to what you say Byrd told you,
yes,
Byrd used the word extortion. That's the word Patricia Byrd used.
Yes, ma'am.
That McBanoa used.
That's correct.
Okay. Now, when you heard this story, that would be very helpful, right, to Donna Adelson's case. Did you call her prior defense counsel and say, listen to what this lady's telling me? Can I have permission to record this? Can I do a recorded interview with her? This is going to be very important. You didn't do that, did you?
I did call them immediately when I left the jail, and I sent them an email with my summary within an hour.
Okay. Did you ask to go then do a recorded interview with her so you would have evidence of that?
No, I didn't ask.
Okay. And did they ask you to?
They didn't ask me. No, I told them what they told me, and if they have any additional instructions for me, I'll gladly go do what they asked me to do.
All right. Now, if Miss Byrd After all that, do you know why the defense never listed Patricia Byrd as a witness?
I don't know the specific reason. I'm not the attorneys on the case. That's
Do you
their
know why
job.
these attorneys never listed Patricia Byrd as a witness?
State allow the witness to answer the question before cutting off, please.
Ms. Dugan, please wait for him to finish the answer.
Just repeat, please.
Do you know why either defense counsel never listed Patricia Byrd as a witness?
I have no idea.
So she has no. So Patricia Byrd was never listed on any defense witness list, and this is such an important witness. This is a witness that's going to save the day for Donna Adelson. Why, as a defense, this would be malpractice. This is ineffective assistance of counsel, 100%. If you've got a witness who's going to say this, and you don't list that witness on a witness list, no questions asked. Ineffective assistance of counsel. You get a new trial. How can they not list this witness? So that was, and again, no attorneys, according to the prosecution here, no attorneys listed Patricia Byrd. But now, actually, listen to what happens next. Because now on cross-examination, let's see what comes out in cross-examination. Or this is redirect.
Overruled, please let him finish his question first before you reject.
Thank you, Your Honor. Would it surprise you to learn that prior defense counsel, in fact, listed Patricia Byrd on the witness list that they submitted prior to this case being set for trial September of 2024?
Would that surprise me? No.
So there you have the defense attorney saying that's not true at all. He actually did list Patricia Byrd as a witness list. I mean, the prior counsel listed Patricia Byrd as a witness. So now there's a real big problem here because you have the prosecution saying, asking us cross-examination that you never listed it. And then you have the defense attorney saying somebody did list it from the defense attorney until her story changed all of a sudden. And then we decided not to list her, right? That's what the defense is suggesting. The defense is saying, yes, this is what is all between the lines. The first attorney, let's say Dan Rashbaum, let's say, I'm assuming is before September 2024. So they listed Patricia Byrd because that's when she was being honest. She's told this private investigator everything that was true. And then all of a sudden she decided to work with the state, and now her testimony is going to change. Well, now that's why the defense did not list her. But initially she was listed on the witness list. And the prosecution's argument is she was never listed on the witness list. So someone is not saying the truth, right? That's what it seems like. So what happened today? Well, now look what happened in today's trial. So now we go to all the way at the end, which is why a lot of people could have missed this. We got to play it for you because this is very important. Here we go.
There is one matter, Judge, that I thought we might be able to reach agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors. Or we can decide the language now. If you find that more acceptable as a one-liner, the parties have stipulated or agreed that Patricia Byrd was never listed on the defense witness lists.
As to that,
So they have a stipulation. Okay, this is at the close of evidence, everything that closed today. And here you have Georgia Kaufman saying that we have agreed that we're going to read a stipulation to the jury that Patricia Byrd was never listed on any defense witness list. So now there's going to be a stipulation read to the jury saying that both attorneys agree basically that the defense was the one who lied yesterday or suggested something that was inaccurate, that Patricia Byrd was listed on a witness list when she was in fact not listed. And this is very bad. Okay, so this is a part of the trial where there's no witness on the stand. And this is a part which could really affect tremendously a jury's feelings about the defense. When the defense gets up there and says that she was listed on a witness list, and now there's going to be a stipulation read that we agree that she was not, that's a problem. And you can come back to that in your closing argument. And you better believe, I would assume, that George is going to come back to that and saying, you may have heard that, but that's actually wrong. You may have heard that Patricia Byrd was listed, but she was never listed. You know why she was never listed? Because that was all not true. Someone made it all up. Wasn't recorded or anything like that. Okay, and then once the jury, like we always talk about, once the jury sees that one of the attorneys loses credibility for one part, they can really just discount that attorney for anything that the person says. So this is a very, very significant victory for the prosecution in this area, and it's going to affect the entire case, I think. Okay, now one other very important issue that came up also at the end of the day today. So let's get there. And this has to do with the planner. Now we know about Donna Adelson's planner, about having Dan Markel's license plate in that planner and some other plans in that planner from 2014 as well as 2023. So now look what the defense does here. This is really when the defense already rested. But look what he does here.
Your Honor, yesterday, the state, or sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my clients. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar. That is, I believe it's State 51.
Okay, so this is basically what he just did, is that he moved to admit the entire calendar and the entire planner, because there's also some notes in there that, she was trying to sell some jewelry and other things. There's also some notes in there that she really wanted to sell this jewelry way before all this happened. And that's what they wanted admitted, to show that she was not just planning to sell her jewelry right before she left Vietnam. She was planning on selling that jewelry a long time ago, way before any of this happened. So they want to admit the entire calendar, the entire planner of 2014 and 2023, because the prosecution only wanted to admit some of the portions of the planner. And therefore, the defense moved under the rule of completeness, which generally means that you can't just introduce a portion of a recording or a portion of a statement or a writing. So they want all of this admitted. Okay, and this was argued back and forth. The prosecution obviously objected to it, and the judge said he's going to take it under advisement. So we did a little bit of research. That's what we like to do here. So I want to pull up for you what the statute says about the rule of completeness and what the ruling most likely should be in this case. Can't say what he's going to do, but what it should be. So take a look. This is the statute, Florida statute, that has to do with the introduction of related writings or recording statements. Here we go. This is the rule of completeness. When a writing or recorded statement or part thereof is introduced by a party, an adverse party may require him or her at that time to introduce any other part or any other writing or recorded statement that in fairness ought to be considered contemporaneously. Okay, so one of the things that actually Judge Everett mentioned, and again, this was on the fly, so you can't blame him for it, but he said, isn't there a difference between a writing and a recording? There may be a difference, and this is a writing, it's a planner. And the answer is there's no difference. This is the statute. The statute says that there's no difference, right? When a writing or recorded statement. So the rule of completeness applies to both equally. But look at this other part of the statute. It says, may require him or her at that time to introduce any other part or any other writing or recorded statement that in fairness ought to be considered contemporaneously. Contemporaneously is, again, at the same time. So this, if you just read the statute, it says that, sorry, Joshua Zellman, sorry, Jackie Fulford, you guys were asleep at the table again. If you want to use the rule of completeness, it has to be at the time that the prosecution is introducing and admitting that part of the statement. So this similarly would be, let's say, in Karen Reed's case, when they're playing only certain parts of her documentaries and videos and interviews, would be that at that time, you would have to argue, Judge, they have to play the entire interview or other parts of the interview. And again, it's also limited to the context. So it has to be limited to the context of the statement that's given. Can't just be all statements that have nothing to do with it. Here, again, the argument is actually a good argument that it does help with context. When she's saying that she wants to sell jewelry before she leaves Vietnam, and she's going to say that, yeah, we wanted to sell this jewelry for the past 3 years, that helps put that into context. So that would definitely be a good argument. The question here is, were they asleep at the table? And it's too late now. So if you just look at the statute, it seems pretty clear, sorry, you lost. You should have been not sleeping at the table. Should have woke up a little bit earlier. But we do have a case. In the case, this is Schreiber versus State. Take a look what the case here says. Okay. Although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. So you see that this is the case where it extends the time period to allow even for cross-examination. Now, we're not on cross-examination now. We are not. Cross-examination is obviously over. Whoever was introducing the planner, was it Sergeant Corbett or is it Pat Sanford? Whoever it was, that he's off the stand. He's not on the stand. So this is not cross-examination. So even though you have a case here, and I looked through some of the other cases, and I did pretty brief research, if you guys want to do your own research and be able to find where maybe you can admit even this, the rule of completeness would apply even for at the close of the evidence, when the person's not even on the stand, then go ahead and knock yourselves out. I couldn't find the case, but again, I only spent a few minutes of research doing this, maybe 20 minutes, and all I can find were cases like this where it said that you can wait up until cross-examination. But now we're definitely after cross-examination here. So if we're after cross-examination, well, it's perhaps a little too late. Now, the question would be, is that ineffective assistance of counsel? You can make an argument for that. I'm not sure if it's going to get you anywhere because, ineffective assistance is a tough burden. And especially if this would have really made the difference in the case, there's a lot of other pieces of evidence here. So that's a whole different analysis. But what I wanted to show you is that it seems that they're just out of luck. It just seems that they're just out of luck because even though the statute is very rigid and you have some case law that expands it a little bit, but not up until the end of trial when, okay, we're just going to admit this as the full document without any context, without anything, without anybody being on the stand to lay a foundation or anything like that. So we will see what Judge Everett makes a ruling about these planners. But I think, based on my limited research of the subject, that it's just too late and it should not come in. So that is where we stand today. A very interesting day for some of these other parts that happen, not necessarily with the witnesses. So that's going to be it. Join us tomorrow for closing arguments, starting at 9 a.m. right back here, Brother Counsel Studios, and we will see if we get a verdict tomorrow. That's going to be it. If you haven't yet, please subscribe. It's free. It's very helpful for the channel, so just hit that subscribe button and hit the like button, and I'll be appreciative. And we'll see you tomorrow. Have a great night.